So turning back, what exactly does FRAND mean? FRAND stands for fair, reasonable, and non-discriminatory. And it's the obligation that a patentee who owns a patent that's essential to a given standard, license that patent on fair, reasonable, and non-discriminatory terms. So just unpacking that, what exactly is a standard? Standards are widespread in the telecoms sector. So, for example, 3G, 4G, 5G. And they allow competitor products to interact with each other. So an Apple handset can talk to an O2 phone mast, which in turn can talk to a Samsung phone, a Huawei phone, etc. And that's possible because all of those devices operate to the same standard, which is basically just a set of technical specifications that set out the technology that all of those products use. These specifications incorporate a huge amount of cutting-edge technology, and that technology has been contributed by a range of different companies when the standard was created. And when a given company provides their technology to the standard, any patents that protect that technology are declared to the standard as well, declared essential. And the owner of the patent, in exchange for their particular piece of technology being incorporated into the standard, provides an undertaking that they will license that patent on fair, reasonable, and non-discriminatory license terms. So just taking a step back, why is FRAND important? It's really now making up a significant proportion of the patent cases we're seeing going through the courts. So just some figures on the slide there. In 2020, 3 of the substantive patents court decision out of 10 were FRAND related on kind of technical issues. 2 of the 9 patent related court of appeal decisions were FRAND related. 1 of the 2 Supreme Court decisions, which is what we'll talk about today, and there were 17 separate interim judgments on FRAND related issues. FRAND really generates a lot of satellite litigation on issues such as jurisdiction and confidentiality, as well as a range of other issues. That's partially down to the value of the licenses in dispute, and also the natural nature of the companies and the licensing. Great. So what exactly is the obligation to give a FRAND undertaking? The reason that SEP holders have to give this undertaking is essentially to stop them abusing their position once their technology has been incorporated into the standard. Because once it has, then anyone who wants to use that standard, so say anyone who wants to make a 4G enabled phone, will need to inevitably use the 4G technology and will need to inevitably infringe any patents that are essential to that standard. And so an SEP holder that owns one of those patents could theoretically stop anyone and everyone from using the 4G standard, and either could keep competitors out entirely or just charge extortionate license fees to their competitors or to anyone really. Even if you just own 1 patent essential to that standard, in theory, keep other people out from using it. So that issue is called hold up, where the SEP holder holds up the implementer, the people trying to use the standard. So to balance that, they are required to give their FRAND undertaking. And that leads to a separate issue, which is that the licensee, the implementer, can then try and hold out from taking a license and say that the SEP holder is not offering them FRAND terms and therefore they're not obligated to take the license from that SEP holder. So basically the courts are trying to balance these 2 interests, the SEP holder and the implementer, this issue of hold up and hold out. And they do that through a contractual lens, so the undertaking given by the SEP holder. But they also do it from a competition lens as well, because there's a risk in this space that SEP holders could be abusing their dominant position in breach of Article 102, or the UK equivalent of Brexit, And so if they fail to offer FRAND terms, they are at risk of abusing that dominant position. So why is FRAND so important now? Obviously, it's very important in the telecom sector. Anyone producing a handset, anyone operating in the telecom space needs to use these patents, and there's a lot of litigation there. But also, we're starting to see litigation in the automotive sector as well. There have been some so-called connected car cases where cars are 3G, 4G enabled, and they're running into the telecoms standards, and there's been some FRAND litigation there. But as standards become more important to cars, for example, in autonomous vehicles or around electrification of cars and their standards around, say, charging, there's a risk of FRAND litigation there as well. And we have seen FRAND litigation in other areas such as video coding as well. So it's not exclusive to the telecom sector. So turning to the kind of key case, a key UK case on FRAND, it's this Unwired Planet case, Unwired Planet against Huawei. And you'll see here that this case kind of started back around 2015-16. And depending on how much you know about patent law, but essentially this case started like a standard patent case. And that's how these FRAND cases generally work. So there were licensing negotiations between the SEP holder and the implementer. So in this case, the SEP holder was Unwired Planet, and the implementer was Huawei. And when those negotiations broke down, then the SEP holder sued Huawei for patent infringement. And at that point, assuming that you have a valid and infringed patent, then you're entitled to an injunction to stop the implementer infringing. And that at that point, it's still just like a normal patent case. But Huawei is then entitled to raise what's called a FRAND defense, where they argue that they've not been offered fair, reasonable, and non-discriminatory license terms by the SEP holder, by Unwired Planet. And therefore, they say Unwired Planet is not entitled to an injunction. So another kind of key issue with these FRAND cases to be aware of is that an SEP holder typically owns a huge portfolio of patents. So not just one or two, but you're talking hundreds, possibly thousands of patents in a portfolio. And they begin by litigating a set of those patents. So in this case, there were 5 separate technical trials to determine whether Unwired Planet's patents were valid and infringed. But assuming that at least one of those patents is valid and infringed, then the case moves on to the FRAND trial to determine whether Unwired Planet has offered a fair, reasonable, non-discriminatory license to Huawei. And that's where the kind of key FRAND issues in the case kick off. So the first judgment on the FRAND trial was issued by Mr. Justice Burst back in 2017. It was a 200-something page judgment. It was totally novel at the time. And he kind of basically formed the UK position on FRAND. And then in 2018, the Court of Appeal fragged most of Mr. Justice Burst's judgment, or at least the issues that were appealed. And then in 2020, the Supreme Court issued its decision on the same issue. Although it's kind of referred to as the Unwired Planet case, it was actually a joint appeal. It was heard together with the Conversant case, which is actually Conversant against Huawei and ZTE. So again, Conversant is the SEP holder, Huawei and ZTE were the implementers. But it arose in a slightly different situation. Here it was a much earlier stage in the proceedings, and Conversant was seeking permission to serve out of the jurisdiction on parent companies of Huawei and ZTE. And in order to do so, they needed to show that the UK was the most appropriate forum, because Huawei and ZTE had challenged the UK's jurisdiction, arguing that the UK was forum non-convenience. So Mr. Justice Carr gave permission to serve out, finding that the UK was the appropriate forum. And the Court of Appeal, again, pretty much upheld Carr's judgment. And then that issue again went to the Supreme Court. So what did the Supreme Court find? Well, one of the key findings was upholding Mr. Justice Barrett's original decision that a global license could be FRAND. And it's slightly difficult to see why that's important, but essentially the outcome is that the implementer either faces an injunction in the UK, or they have to sign up to licensing terms that cover the entire world, including non-UK patents, and including products sold everywhere in the world. So it's called a kind of global license, global FRAND license. The implementer is faced with this choice, and some people say, it's incredibly burdensome for the implementer, and the UK courts have massively expanded their jurisdiction by forcing this global license on. And so that the UK courts say, well, what we're doing is deciding infringement issues in relation to UK patents, and the implementer then at that stage would normally be faced with an injunction if it was a normal patent infringement case. But what they have decided to do is raise their FRAND defense. And at that stage, they have the choice to accept a court-determined FRAND license. They can always choose to accept the UK injunction if they don't want to rely on their FRAND defense. But if not, then they need to accept whatever the court determines to be a FRAND license. And if it determines it to be a global license, then that's the license you need to accept. And the courts have said that in practice, in industry, it is a global license that these people negotiate. Large players selling handsets across the world don't negotiate country by country; they negotiate for a global license. Huawei also raised an argument before the Supreme Court that hadn't been dealt with before, saying that damages should be awarded in lieu of an injunction. Basically, because it was disproportionate toward an injunction, which would essentially shut Huawei out of the UK market if they were injuncted, and people wouldn't be able to buy Huawei phones in the UK. And the court said no, Huawei always has the option to accept this FRAND license, and the court has determined that it's fair, reasonable, and non-discriminatory. So that's a perfectly reasonable option for Huawei to take if they don't like the UK injunction. And there's been a lot of disagreement about that subsequently, but that's what the courts decided in the UK at least. And one key distinguishing feature of the UK approach is that the court will step in and set the license terms itself, including the royalty rates. So if it decides that the SEP holder's offer was not FRAND, then they will go through and essentially write their own license. And in relation to the royalty rates, they will determine the royalty rates themselves. They will set them in that license. And they do that kind of using two different methods. One is called the comparable license approach, where they look at similar licenses in the industry, similar licenses that have been offered by the SEP holder and been offered to the implementer, and try and come up with a fair equivalent figure for this particular situation. The other approach is called the top-down approach, and there they look at the proportion of the handset price that they think kind of should be paid as a royalty, and then they look at so say if you sell a handset for £100, and they say, well, £5 of that should be a royalty to use the 4G elements on that handset. Then they look at the proportion of patents essential to the 4G standard owned by that SEP holder. So say it's 20% of all the patents essential to 4G are owned by this particular SEP holder. You just multiply those numbers together. So in that case, £5 by 20%, you are entitled to a £1 royalty on every handset sold. Those are just made up numbers, but that's the approach. It's a pretty rough and ready approach. And so the court says the comparable license approach is the main one to take, and the top-down approach is just a kind of cross-check to make sure that that's a reasonable figure that you're getting. On jurisdiction, the court rejected Huawei and ZTE's challenge on the basis that they've not pointed to an appropriate alternative forum that could decide the dispute. And it's kind of a technical issue, basically. In order to make out a forum non-compeniens argument, you have to have another forum besides the UK, and the Supreme Court said Huawei and ZTE hadn't done that. In this case, they said they hadn't done that because they had pointed to China as the appropriate alternative forum. And the lower courts had already found on the evidence before them that China didn't have the jurisdiction to determine global FRAND licenses. Now that's kind of subsequently changed, but at the time that was the evidence before the court, and so that's how the Supreme Court decided. But they did say obiter that in a FRAND case, the key issue in the dispute is infringement of the UK patent rights. And the FRAND elements are kind of, it's raised as a defense and therefore ancillary to the key issue, which is infringement of UK rights. And so by that logic, it's hard to see how the UK could ever not be the most appropriate forum, because it's a UK national right, and it therefore makes sense to be decided in the UK. So the court's kind of set itself up to always have jurisdiction over FRAND disputes in the UK, at least relating to the UK. And this reasoning has then subsequently been applied in the case called Phillips and TCL. There were parallel UK and French proceedings. There were some issues around exactly when the proceedings were commenced and exactly when the FRAND defenses were raised in the different proceedings. And it's worth noting as well that the undertaking, the FRAND undertaking in this case was governed by French law. So there was an argument that the French courts were more appropriate to determine the issue in that undertaking. But that jurisdictional challenge failed. The court said, applying the reasoning of the Supreme Court, well, no, it's an issue of infringement of UK patents. That's the key issue in dispute. The FRAND elements are ancillary, so we have jurisdiction. And the FRAND determination can continue in the French courts, that's a separate issue, but we'll get to it in the UK once we've decided the issue of the infringement of the UK patents. So jurisdiction is quite a complex area for FRAND, but essentially at the moment it looks like the UK has jurisdiction in almost every circumstance. A couple of other key findings of the court. One is on what exactly the non-discriminatory element of FRAND means. So there was an argument that it should be a so-called hard-edged requirement, which means that you are required to, as an SEP holder, you're required to offer license terms that are no less favorable than you've offered to other similarly placed competitors. So if you've offered good license terms to X company, then you must offer at least as good license terms to the next one who comes along. And one of the reasons this was particularly relevant in the Unwired Planet case was originally Samsung was also a defendant in the case, and Unwired Planet had settled earlier on in the proceedings with them on fairly favorable license terms. And so Huawei was trying to take advantage of those same license terms by arguing that it was a hard edge requirement and they were entitled to the same terms that Samsung had got way back at the start of the proceedings. And the Supreme Court said, no, it's not a hard edge requirement. You can offer terms that are better than FRAND to other competitors if you want, as they did here with Samsung. And to do otherwise, that would disincentivize the SEP holder to settle with parties, because if they're worried that whatever settlement they make is always going to lead to a race to the bottom, the SEP holder isn't going to settle. They're going to hold out for the best terms they can get. Otherwise, they're going to have to offer better and better terms to subsequent players entering the market. So the Supreme Court said, no, not hard-edged, which basically makes the whole kind of FRAND requirement a bit fuzzy. You have to kind of read fair, reasonable, and non-discriminatory all together. And it's slightly unclear how you unpack that, but that's probably an issue that remains to be resolved. Another issue is exactly how you have to go about these FRAND negotiations. So there's a prior CJAU case called Huawei and ZTE, where the CJAU set out the steps that an SEP holder would have to take in order to avoid abusing its dominant position. in breach of competition law. In some countries, these steps are applied quite strictly. So each party, the SEP holder and the implementer, has to go about complying with those steps very carefully. Otherwise, either the SEP holder will be entitled to their injunction, or the implementer will be entitled to their FRAND defense. But the UK court has said no, it doesn't require strict compliance. The requirements in Huawei ZTE are that they provide a safe harbor. So if you do follow them, then you won't be abusing your dominant position. But if you don't follow them exactly, that's okay, as long as you as an SEP holder have notified the implementer of your rights before you start proceedings, and preferably have consulted a bit with them. Then that's fine. You don't have to go through a whole set of steps set out in the Huawei ZTE judgment. So the UK takes a much more relaxed approach than other countries. And turning to the position in some other countries, the Unwired Planet judgment really was significant, not just in the UK, but around the world. It set the direction in a lot of different jurisdictions, particularly on this willingness to say that a global license is FRAND, and that the court will step in and determine those global license terms. So taking China first, in this Oppo and Sharp case, the Chinese courts have now confirmed that they definitely are able to set global FRAND license terms. And that inevitably leads to the question, well, what happens when the UK courts try to set one set of terms, Chinese courts set another, and there are other jurisdictions that also potentially can set their own license terms. And that is an issue that has yet to be resolved. It's definitely a real issue in FRAND litigation as to exactly how that works. In practice, in the UK at least, at the point that the court sets the license, you have to choose between the injunction and the license. And if you choose the license, you will have signed up to those terms. And so it doesn't really matter what other courts determined of the license terms, because you've already signed up to them. So in practice, maybe it will be more of a race to judgment than a case of competing judgments. In Germany, the CIPIL and higher case confirmed that the German courts take a very strict approach to the pre-proceeding phase, the negotiation phase, and are quite strict on implementers. So the implementer has to take very active steps to seek a license from the SEP holder, and they have to be quick in their response to negotiations. Otherwise, they risk violating their FRAND defense, and therefore the SEP holder is entitled to their injunction. So there's a much higher burden on the implementer in Germany than there is in the UK. And in the US, there have been a lot of different cases dealing with lots of different aspects of FRAND. One that I would flag here is TCL and Ericsson, which kind of sets out or highlights one of the kind of slightly crazier issues about the US system, which is that juries get to determine damages in patent cases, and this case confirms that juries also get to set FRAND license terms themselves. So in this case, the license terms had initially been set by the judge on a very similar basis to the Unwired Planet case of the UK, and the judge set out their reasoning for why that was and applied all of their calculations. But on appeal, it was determined that the defendant has a constitutional right to have a jury determine damages on appropriate license rates. And so it's confirmed that juries have to set these licenses. And then the issue, of course, is that juries don't necessarily show their reasoning. So you can get these just astronomical damages judgments in some cases without much justification, which is an interesting situation in the US. And one issue that arises with all of these different jurisdictions is, as we've kind of touched on a little bit, is what happens when you have competing proceedings. And one trend that's been cropping up quite recently is the case of anti-suit injunctions. So, for example, in Ericsson and Samsung rushed to the Chinese courts and sought an anti-suit injunction to stop Ericsson bringing proceedings against them in any other jurisdiction besides China. At which point Ericsson rushed to the US, to the Texas courts, and sought an injunction blocking the enforcement of the anti-suit injunction. So that's called an anti-suit injunction. That case settled, but there have been lots of other fights. I think the highest they've got to is 5 antis before the suit injunction. And these cases are clearly kind of crazy, with parties just fighting over jurisdiction before you even get to the proceedings. In Europe, we don't tend to issue anti-suit injunctions, but are very ready to issue anti-suit injunctions. So Europe views the restriction on where you can sue as quite anti-competitive, but is willing to stop parties trying to play those games. There was a case, IP Common Lenovo, where the US courts had issued an anti-suit injunction, and both the UK and France issued anti-suit injunctions. And there are lots of other jurisdictional fights to be had, jurisdictions like India and France, etc. They're all over the place, really. So there's lots of that jurisdictional fighting to come. In terms of what's next for FRAND, I talked a little bit about the connected car cases already. So there was the Nokia and Daimler case in Germany. And this actually raised some issues that kind of don't really crop up in the telecoms industry. So there, it's quite a simple and well-established model where there are a bunch of SEP holders, there are a bunch of handset makers take licenses or not from the SEP holders. But in the automotive industry, it's much more standard for the component suppliers to take the IP licenses and then supply the components to the final vehicle manufacturer. And there was a fight between Nokia and Daimler. Daimler said they should have to take a license. They should be entitled to force that obligation onto their suppliers to take the licenses on the components. And Daimler doesn't want to deal with its IP licensing. Nokia said, no, we don't have any obligation to offer FRAND terms to the suppliers. We only have an obligation to offer FRAND terms to you, Daimler. You have to sign up to our FRAND terms. And one issue that arises there is it's potentially quite a different scenario offering if it's a percentage license, offering a 5% license on a £20,000 car versus a £50 piece of component to be incorporated into that car. There are arguments about whether in practice the dollar amount actually changes and the percentages are adjusted to make sure that the dollar amount of the license is the same regardless of what you're licensing. But that remains a kind of contentious issue between SEP holders and vehicle manufacturers. There was a CJAU referral on that point, but unfortunately the case settled before that was resolved. So that remains an open question. And as I said, there are other questions around what happens with standards around self-driving cars, around electrification. There is a lot more scope for disputes there in the future. There's also a growing group of people who think that this current system of fighting over FRAND disputes in various different national courts isn't really working right now, or isn't the best use of the court's time. And that includes some of the UK judiciary. And one alternative that's been proposed is FRAND arbitration. And there have been some cases that have been resolved through arbitration. It's unclear exactly how many, because obviously arbitration has to be fairly confidential, but there are some that are known about. But the issue is obviously that with arbitration, you need both parties to agree to arbitrate. If you don't, then it's difficult to impose arbitration on parties, at least under UK law you can. And so without some kind of international tribunal set up or international agreement, it's hard to see how this arbitration is going to become more widespread. But that's been a proposal by some, at least. It would potentially deal with some of the issues that have arisen around jurisdiction. There have also been consultations from the EU Commission and the UK IPO, looking for new ways to deal with FRAND and ways to address current issues or perceived issues in the FRAND licensing and disputes current landscape. So one issue that's been mooted is At the moment, SEP holders declare their patents to be essential, and there's no check at that point on whether the patent is in fact essential to that standard. And so there's a clear incentive for the SEP holder to declare as many patents as possible to be essential, because then they can say, I'm licensing you 10,000 patents instead of 100. So some people argue that there's an inflation in the number of truly essential patents. And at the moment, there's only a check on essentiality when the courts actually consider the issue of validity and infringement. And they only do that with a small subset of the patents typically in the portfolio. So there is a suggestion that one way to deal with that would be to run an essentiality check much earlier on. And basically, when a patent is declared essential, have some independent body determine whether it's truly essential. There's obviously issues with costs around that scheme, because it's potentially very costly with thousands of patents to be declared essential, and also whether anyone's really going to trust that essentiality check as well. And there are lots of other proposals mooted by the EU and the UK IPO, so there'll probably be some new legislation or new ideas coming out around that. Another area that's much broader than FRAND is the Unified Patent Court, which will be coming later this year. And it looks like the UPC will have jurisdiction to determine FRAND issues, at least when raised as a defense to patent infringement, probably not as a declaratory action. But it's unclear how the UPC is actually going to approach FRAND issues. So in some countries like the UK and Germany, and to some extent France, it's fairly clear now how the courts deal with the issue of FRAND. But the UPC is a totally new court. It's not clear how they're going to deal with any issues really, but also not clear how to deal with FRAND issues. And there is a question for SEP holders now as to whether they opt their patents into the UPC or out of the UPC, and keep them as EPs litigated in national courts for now. So that's another interesting area to see coming down the line later this year. And finally, there are a lot more UK cases coming. There still continues to be a huge amount of FRAND litigation in the UK courts. So far, the only true FRAND trial, or FRAND judgment at least, has been the Unwired case. But there was a trial on the Interdigital and Lenovo case in January of this year. That was a full FRAND trial, as I understand. And so that may be the next big FRAND judgment that probably will answer some questions and potentially open a whole new bunch of questions that will go up through the Court of Appeal and maybe again the Supreme Court, as long as the case doesn't settle before then. And another case to watch is the Optus and Apple proceedings. And there was a recent finding there that Apple was an unwilling licensee for not unconditionally accepting the UK court determined FRAND terms at the beginning of the proceedings. Optus said that Apple should have undertaken to be bound by whatever the court said was FRAND right at the start of proceedings, and Apple refused to do that. And there's a question therefore as to whether it was an unwilling licensee. So far, the court said yes, that's the case. I suspect that issue will be appealed, but it remains to be seen. And interestingly, in that particular judgment, Apple suggested that they could potentially pull out of the UK market if they were forced to take a FRAND license, a global FRAND license. I mean, it seems unlikely that we'd all stop being sold Apple phones in the UK, but it's quite a big threat. And it has happened before, albeit in relation to a much smaller player. There was a dispute between companies called T2 Delta and Zyxel, which probably you've never heard of, I've never heard of. But Zyxel did accept the UK injunction, waived its FRAND defense, rather than being forced to accept a UK determined FRAND license. So, so it is a possibility, and it'll be an interesting set of proceedings to watch. And I think that's kind of everything I had to cover. So,
okay, yeah. Thanks.